we were in a trial setting. Not that I'm deprived presently of the opportunity of doing that, and hence me raising this objection. The second issue concerns what actually appears in this document, which will then tell you that what Mr. Meyerberg now has done is to put that this document's creation date is the 19th of February 2018. And to put that as a fact is wrong. Because you see, and regrettably in small print, what this deponent has done is he says there's a reference to a footnote. That very footnote is not of relevance. But if you turn the page, there is also a creation date at paragraph 22.1 that talks about file created, and then there's a footnote at number 11 in small print, which reads, date created or date copied from one drive to another, and open brackets. This is not necessarily the original creation date, but this is how NTFS file system stores dates, closed brackets. There is no certainty, one from the methodology employed, which is lacking in this document. And for instance, I just want to add to that, if you were to analyze hard drives, you would talk about the insertion of certain equipment or items, a write blocker, which would prevent a duplication or perhaps interference with that electronic data. There's no reference to any of that. But what we see in the footnotes is that what is being presented here is not certain. In other words, it's capable of variation. So we cannot put to the witness, with respect, that that is definitely the creation date. If we have to have regard to that, and I want to avoid a situation where, because of the time pressures that the Commission is working under, me having to re-examine Mr. Gama on this point, the position is, if this document was created on the 19th of February 2018, and we look at the time zone, and I'm going into a bit of detail here to demonstrate my objection, that UTC is something that applies to Europe, and perhaps even the United Kingdom. It's not something created in South Africa. So if the suggestion is that this document was created on that date, I want to make it clear that it couldn't have been created by Mr. Gama. But we can't begin to accept that there's any truthfulness or that that assertion is in fact correct by virtue of what appears in the very document. So that's my objection, Mr.
Thank you. Mr. Meyerberg.
Mr. Chair, I think this may be a lot to do about nothing, because Mr. Gama himself says that I no longer had the invoice that was printed in 2017, so I asked the hotel for another copy. So it was more than likely printed in 2018. We're not suggesting that Mr. Gama has fabricated the invoice at 341. What this metadata reveals is that the invoice was in fact created at the UAE by the hotel, but it's the date that's of significance to show you that we're dealing with two different invoices. If he's accepted that he gave the journalist the 2017 invoice and then he went and got another invoice in 2018, and that's common cause, then I suppose to a large extent the metadata falls away, because if Mr. Gama gives us the email where he requested the invoice from the hotel and he can give us the string coming back, then presumably the creation date would correspond. But if I could just show you one thing, and that is that what the deponent says at paragraph 24, I confirm the results from e-case by assessing the properties of the document in Abode, Acrobat Professional, and also by extracting the metadata of the document with an EXIF tool. The results are noted in Annexure CL2. Now CL2, you'll see, Chairperson, is at 351, and there you see very clearly that this was created, it says, on the 19th of September 2018. So I will consider my learned friend's objections, and if necessary, we can improve this affidavit. But as I say, if we can get the the email string from Mr. Gama, then presumably it may very well add up to this and not be an issue.
Yeah, okay, okay.
Mr.
So,
Chair, given the response by my learned friend, I'd ask that he then holds over on further questioning in relation to this particular document. We are happy to provide him with copies of the emails.
yeah.
Thank you.
Okay.
I certainly have no more questions.
Yeah, no, that's fine.
I do want, though, to...
I guess the email can be provided by tomorrow afternoon
Yes.
when we start, we resume. Okay.
Yeah. Chair, I just want to say, I don't know, I don't think we need, or we needed any expert to send you these kinds of documents if the issue was these invoices, they don't look the same. The contents of the invoices are exactly the same. But one was obtained later than the other. That could have been verified with me. It doesn't need, what do you call this kind of person?
This particular expert.
It doesn't need this MacGyver, I don't know what they call this, digital forensic.
Well, perhaps I
No,
could just...
that's fine, because I think there is agreement that let's wait until the email has been provided and take it from there.
I think the reason why we got the affidavit will become clear now. So, Mr. Gama, when I was questioning you on the 30th of April at page 77 of the transcript, you said, yes, I did not have a copy of the bill. So I approached the hotel to send me. I just gave them the dates when I was there. I say, yes, but this paragraph reflects that you provided the journalist with an invoice. Mr. Gama, yes, it could be this invoice. Now we're talking about 250.341.
Yeah, so,
I say, just if you bear with me, I say, but how can it be that invoice, because it's recorded here unless it's wrong, that the invoice does not show the hotel's name? We're referring to the journalist's article. It does not say you settled the bill and was printed in June 2017. Mr. Gama, he probably got it wrong. Myberg, all right, do I understand that you say that you sent this invoice, 250.341, to the journalist, and you say yes?
yeah, I think there was no clarity that the contents is the same invoice. It hasn't changed. But an invoice that is generated in 2018 could not have been sent to somebody in 2017. I think that's clear. Here, I think it's a matter of semantics, really. All I said was the contents of the invoice are the same. In fact, when I was asking for a copy of the invoice, I used the dates that I was there, and I said, these are the days that I was there, can you send me a copy? And they sent me a copy. And the contents of the invoice, numbers and whatever is in the invoice, it hasn't changed.
And then to drive the point home, you say, I sent him this invoice, 250.341. You say yes, I say right, you say yes. There is not any other.
Can we agree that the contents remain the same? They haven't changed?
They have changed, Mr. Gama, because the one has a stamp date, the one has a date when it was printed, the other doesn't. We've gone through that. But the point is that you told the chairperson that you sent the journalist 341.
No,
and that's why we needed...
I said to you, and you've just quoted me.
Yes.
I said to you that it could be. That's what you quoted just now. I don't have this thing that you are reading from my transcript. But if you gave me a copy, we could both quote what you've just quoted. You just said to me that I said it could be. I never said it is. But the contents, Chair, as I persist with this matter, the contents, in terms of what the amounts were and all of that, they remain the same.
Well, we can if you do need to see the transcript, that can be done either now if there is a copy available, or it can be obtained and later on it can be given to you, and then questions can be put
Yes,
after you've had a look.
I'll let my learned friend have my copy and he can deal with it in re-examination.
Yeah, okay.
Now, just to pick up on one issue, and you confirmed what is stated in the article, that you raised with Mr. Essa, or Mr. Essa raised with you, his involvement in Trillion during your meeting in Dubai. I just want to make sure that I understand your evidence correctly, Mr. Gama. At what point did you come to learn that Mr. Essa had a shareholding in Trillion?
It was much, much later. It would probably be at some point in 2017 early. So when we were discussing this with the journalist, it then had dawned on me that what he had been talking about creating a black-owned consulting firm, that he may in fact have been referring to the creation of Trillion. But it had become public news at some point, probably in 2017, that he had some kind of shareholding or some interest in Trillion. When I was at Transnet in 2016, as I indicated to you, there was a letter from regiments that indicated that would be forming Trillion. There was no mention of an ESA. It was much later, I think, when one reads too many newspapers, I think that's when that information had come up, that seemed that ESA was also a shareholder in Trillion. But I learned that much later. I wouldn't know. It was certainly around the time when the journalist and I were having a discussion.
Could I take you to a document that is part of Mr. Mohammedi's affidavit? Could I ask you to fish out, please, bundle BB3B? Someone will help you with that. So it should be, Mr. Gama, here on this side, 33B. BB3B.
Yeah.
Could I ask you, please, to turn to page 519? And I'm talking about the numbers at the top, MSM 519.
The bold ones.
No, not the bold one. I think you should find a number above that.
Okay.
Do you see that? An MSM number.
Yeah.
So you remember that you gave evidence as well that you spoke to Mr. Essa about a migration of work from regiments to Trillion, and this is one example of that. You find that at 519. Are you there? You see that this is a...
No, I have never said I spoke to Mr. Essa about the migration of work from regiments to Trillion. I've never said that.
All right, so the article says, quoting you, Essa said, the expertise would remain the same as core resources, would migrate from regiments, and that the quality of the work for Transnet would be unaffected. I think you accepted that last time, correct?
Yeah, we never had a discussion about the name of the entity. I never knew any name in terms of what the name of the entity was.
All right, well, I don't want to traverse ground we've already traversed. I want to try and go forward. If you have a look at this document, at page 522.1, it's signed by you on the 9th of May 2016, 4 or so months after your meeting with Mr. Esser. You see that? And the recommendation at that page is it's recommended that the Acquisition and Disposal Committee approves cession of the above-mentioned contract from regiments to Trillion, an increase in the scope for the detailed capital optimization support services, an increase in the contract value from 375 million to 463.3 million. You see that recommendation?
Yes.
And what I just want to direct your attention to is page 521 under the heading Discussion. It says at paragraph 12, on 13 April 2016, Mr. Wood sent a letter to Transnet Annex B indicating that he's ceding his rights received from regiments to Trillion. 13, Transnet then initiated its to regiments on various assignments, etc. And that's how, Trillion came to replace regiments on this particular contract.
Yes.
And just perhaps you can help me. Is the shorthand for this contract the GFB contract?
Sorry, shorthand?
Is this what is commonly referred to as the GFB consulting contract?
Okay, sorry, I think I'm lost there, Mr.
All right, well, don't worry about that.
You're talking about what was being ceded?
Yes, well, is this typically referred to as the GFB contract?
Yes, at the heading of it says it's a session of the GFB contract, yes, of that agreement.
All right.
That's what was moving from.
So I take it then you accept on the assumption that you read this, or let me not put it that way. Did you read this memorandum before you signed it and recommended it?
In the main, what I understood from the letter that I had was that there was a letter from Mr. Wood to us. So I read that letter. I was not aware that at that time there was already this breakdown in terms of the actual shareholding. So, but I note what it says. It says that there was Daniel Roy, Jan Johannes Fori. There was also the Trillion Holdings, which it says it was wholly owned by Salimisa.
Yes.
And there was someone else, Ariom nominees and the directors, but I don't think I went into much of that detail at the time.
So on the face of this document, as of that time, Trillion Holdings Pty Limited had a 60% shareholding. in trillion, correct?
In this entity, yeah.
Yes. And in fact, that entity derived its BE certification from, on the face of it, that shareholding.
It derived its BE certification from?
From the 60% shareholding held by Mr. Essa.
Yes, yes.
Correct.
So I think that's what people were talking about, but I was not aware that our people actually knew about it and had actually written it. Yeah.
So your evidence is you didn't read this. You read the letter from Mr. Wood.
I received a letter from Mr. Wood, which was attached to the...
But before recommending...
I'm sorry, was that letter, was this memorandum attached to the letter?
No, when the session was requested,
Yeah,
it was on the basis of two letters.
yeah,
There was a letter from regiments
yeah.
and a letter from Mr. Wood, which was indicating what was happening.
Oh,
Yes.
okay.
So paid too much attention, but I see that it... Yeah.
The letter from Mr. Wood would not have dealt with process to ensure that there's no reason why Trillion cannot be a vendor to Transnet. And then that unfolds. In order to recommend...
That's the work that the procurement people do. So I think, as you will see, that is coming from the procurement or chief supply chain officer. He is talking about all of the work that they had done. Yeah.
But are you saying you signed this memo without reading it?
No, that's not what I'm saying.
You're not saying that.
I'm saying that I may have just glossed over it. It was not something that was probably important at the time. Mm-hmm. So it's always interesting with the benefit of hindsight when people say, okay, let's look at this memo. I can see what it says. But what was foremost in my mind was that the work was moving with Wood from regiments to this new entity.
Mm-hmm. So you are saying you didn't read it in any detail. Mm. You glossed over it. Is that what you're saying?
Yeah, I didn't read it in any detail. I was aware of, and I had in possession what they are saying in item 12, where we received a letter from Mr. Wood, which they say is Annexure B. And then it was then saying that he's ceding his rights received from regiments to Trillion Capital. So I think at that time, in my mind's eye, he was the main shareholder of this new entity called Trillion Capital something. Yeah.
Yes, I want to then perhaps move off this topic, but just want to ask you one last question on this, penultimate question. You gave evidence earlier about how you were a bit irritated with Mr. Essa because he almost tricked you into meeting with him at the Gupta residence. Do you recall giving that evidence?
Yes.
Why? I don't know if I've asked you, why did you agree to meet with Mr. Essa again at this time in January 2016, in the light of your previous experience when you met with him?
When you say, why did I agree to to meet with him. Well, I'd met with him. I had been quite curt and clear when I had last met with him. And I had voiced my my anger in terms of what I thought was an ambush. And I dealt with that issue. So if somebody then says, no, I'd like to meet with you about another issue, then I said, okay, fine, let's meet. And he wanted to talk about creating a consulting entity. It wasn't really going to take anything away from me. I probably just spent an hour or so with him. And
I want to just give you an opportunity to comment on this, because sometimes the timelines are lost on one. But by the time that you met Mr. Essa in January 2016 in Dubai, on the money flows investigation, Chairperson, and assuming that that investigation is upheld by you, what we know by that time is that Mr. Essa had taken 50 cents in every rand of fees that regiments had charged Transnet in respect of a variety of contracts. Mr. Essa or one of his companies had been appointed as a skills development partner to regiments. Mr. Essa, through Tequesta and Regiments Asia, had concluded business development services agreements with the Chinese locomotive manufacturers in respect of the 95 locomotives, 100 locomotives, and the 1064 locomotives. And you had authorized payment already to Trillion in December in respect of the club loan of 93 million. While Mr. Essa for a long time was in the background, now he came to the foreground where he was effectively the majority shareholder in a service provider to Transnet. It's in that context that you met him. All of this had been done before. And as I put you already, the money flows investigation is to the effect that what I've sketched to you was part and parcel of a very major money laundering scheme involving the Gupta. That's the context in which you met the man.
okay, Mr. Mayback, is it your contention that I knew about these payments or these money flows that you're talking about? Is it your contention that I was complicit in that? So if that is your contention, then put it to me.
I'm asking you...
Because I really don't know anything about money flows. I don't know anything about what Issa was doing. I had met him at face value. I've indicated to the Commission when I met him. You are telling me what was happening in the background. I was not aware of it. But if your inference is that maybe somehow I knew about it or I was complicit in it, put it to me.
Well, that's what we're investigating here, Mr. Gama, but I start by asking you to comment as you have. And what you've said is that you were unaware of all of this. Do I understand correctly?
Absolutely, I was not aware.
All right.
Are you moving away from this memo?
Yes, I am, DCJ.
This memo, Mr. Gama, at page 519, why would you remember that you didn't read it, but you closed over it? About 5 years, about 4.5 years ago? What would make you remember that you closed over it, didn't read it?
No, Chair. Semantics and English.
English is not my first language either.
It's my third language.
Well, I don't know about Mr. Mayberg, but
Sikhuluma ulimi lwababhemi lapha. So sometimes you go through these documents, you skim through them, you absorb it at the time. But if you ask somebody line by line and say, this document that you read, even if you ask me 2 or 3 weeks ago, and you say, look, here's a 5-page document. I think it's 6 pages.
Yeah, it's 6 pages.
Yeah, so we have this 6-page document. And then you say to me, as Mr. Mayberg does, let's go to this particular line. Even if you ask me after I read it and we sent it to the committee to deliberate, and then you say to me, you know what, there is J.I. Afriat is a director of that company. I'm just looking at something that is in there. I would say, look, give me the document. Let's look at it, because if you're not familiar with the names and the people, you might not remember all of that. So
you would remember the gist.
I remembered all of the gist of it. Normally, these documents, when you sit and you discuss this, you have somebody who sits across from you. You've got the document, they've got a copy. You go through it and you say, okay, what is going on here? And they say, okay, there's an annexure. You say, can I see the annexure? You read it. You say, okay, everything on the face of it looks okay. It means that we can do all of the things that we want to do here. And really that's what happens. But you can't have a 3,000 word document where you then say you would remember line by line every line that was there.
Yeah, no, I'm not suggesting that you should. You see,
because we wouldn't send a document to the committee if we had not checked and seen that the things that we were saying were accurate and all of that. So that would have happened. But if you come and ask me 6 years later if I remember everything that was in that document, as I said to you, I did learn that ISA was a 60% shareholder in one of the trillion companies, but I can't tell you at what point. I can't recall at what point did I learn this.
No, the reason why I ask you is that my expectation is that when you look at a document that you have signed, or that if I look at a document that I signed 5 years ago, I know that if I see my signature there, I would know that I would never have put my signature there without reading the document. Okay. So once my signature is there, and I'm satisfied it's my signature, then I would know that I read it.
No, we would have gone through the document.
Yes. So that's but what was interesting for me is that you were saying you glossed over it.
No.
So as opposed to
not that meaning, no.
Not that meaning.
Not saying I just glossed over it.
So you read it.
Yes. No. We skimmed through it and we discussed it. We may not have discussed each and every aspect of it, but we discussed the document.
But there is having a look at it and not reading the whole document, reading certain parts and letting somebody tell you what it says, which is one thing. There is reading the whole document, even if you discuss it with somebody. So is the position that you did read the whole document?
Yeah, no, I read the document, yeah.
Okay, all right. Mr. Maivek?
But then, Mr. Gama, perhaps I just want to put to you, how come it never, the shareholding in Trillion didn't jump out at you in the light of the fact that just 4 months before you had met Mr. Essa in Dubai?
What didn't jump out?
The shareholding in Trillion and Mr. Essa's involvement.
Why would it jump out per se? Are you saying he wasn't entitled to be a shareholder in the entity?
I'm saying in the light of the discussion you had in Dubai.
I don't understand the question.
All right. Now, we're talking about the cession here of this contract from regiments to Trillion. You will recall that in 2015, the so-called GBF contract was originally awarded to McKinsey and regiments. Do you remember that?
Yeah, I think it was regiments, yeah.
Yeah. I just want to put to you, the money flows investigation has revealed that Mr. Essa got 50 cents every rand that regiments charged on the GBF contract.
Yeah, I don't know that, yeah. You are telling me.
I want to now move to another substantive topic. You'll remember where we ended off last time. I had been questioning you about the ZAR club loan. And there are 2 transactions relating to the financing of the 1064 that I want to deal with. The one was the club loan. The other is the success fee that was paid to regiments of 189 million. Perhaps I could ask you, maybe the most convenient way to deal with this, easiest way, is for me to ask you to go to the POR bundle, please, that you find at bundle 6, exhibit BB27.
Would somebody assist him, or is it a file that he already has?
We'll get someone to help you. We'll put that file away for you.
Page?
I'll be with you in a moment. Yeah, I think Mr. Gama has it. Oh.
Of course.
Could you please go to page 389? I just want
389.
389, Chairperson, yes. I'm just going to take you through paragraphs 2.6.1 to 2.6.4, and then also paragraph 2.6.6. And perhaps you can have open, I think you do at the same time, Mr. Gama. Bundle 7, Exhibit BB28. The collection of documents relevant to this topic, you find page 250.380.
The last page you mentioned was 260.
250.380, Chairperson.
In the same bundle?
No, that's in
in another
in
bundle?
exhibit BB28, Mr. Gama's exhibit.
Oh.
So we need to deal with the POI exhibit and Mr. Gama's exhibit together.
Okay.
So, Mr. Gama, if I could take you then, please, back to BB27. This is an extract from the, or it is the M&S report on transaction advisors. 2.6, the second addendum to the MSA. It says on 28 April 2015, Transnet...
Which page are you at?
2.6 at page 389.
2.66.
The page is 389 and the paragraph is 2.6.
Six.
Yeah.
Are you there, Mr. Gama?
I've got 2.68, 2.69.
Mr. Chair, might
I don't have a 2.6.
It's the black number as opposed to the red. Mr. Gama must look at the black number.
Oh, yeah.
On the left-hand side. I do
Look at the
beg your
black numbers in the pagination at the top.
Oh,
Yeah, not the red ones. Thank you.
sorry. 8, 9.
So it says there
So-
2.6.
sorry, I'm struggling.
Will somebody help him?
You said 389.
Yeah, 389. Maybe somebody who can assist him when there is a need, should not be too far away, so that when
All right.
there is need for
I'll
assistance.
organize someone to be on
Yes, yes.
more readily on standby,
Yeah.
chairperson.
Yeah.
All right, at 2.6, on 28 April, Transnet Group Treasurer, Mr. Ramasabudi, compiled a memorandum which was recommended by Mr. Singh as well as Mr. Gama and submitted to BADIC. The memorandum provides the following. The request to the BADC to approve the contract extension from 99.5 million to 265.5 million for the appointment of Regiment's Capital for transaction advisory services and support to Transnet on the 1064 Locomotive transaction. Summary of the services provided by regiments, etc., in relation to securing the China Development Bank loan in the amount of USD 1.5 billion and a motivation for risk sharing basis payment of 166 million, excluding VAT, to regiments on the basis that the services provided by regiments for a period of more than 12 months were at risk. Now, perhaps you could just keep that open. And let me ask you, please, to turn to that memorandum, which you find at page 250.383.
I'm sorry, just repeat the page
Yes.
and the bundle. Yes, Mr. Mike.
All right.
If you can
250.
repeat.
So now we are in Mr. Gama's exhibit.
Yes.
DCJ one is to read the report and the exhibit together.
Yeah.
Mr. Gama's exhibit 250.383.
Two 250.283.
250.383.
383.
Yes.
Oh.
So there you find a memorandum which you signed and recommended on the 28th of April 2015 that you see, Mr. Gama, at page 391. If I
Yes.
could then take you to the beginning of the memorandum at 383, subject, request to appoint JP Morgan and Regiment's Capital to conclude on the China Development Bank loan. And then it sets out the purpose of the submission is to request the Acquisitions and Disposal Committee to, one, approve the confinement appointment of JP Morgan to hedge the financial risk, in brackets, interest rate, credit and currency risk emanating from the US dollar 1.5 billion China Development Bank CBD loan back into ZAR. 2, approve the confined appointment of JP Morgan to lead and underwrite the equivalent syndicate ZAR loan of $1.5 billion. 3, approve the contract extension from 99.5 million to 265.5 million for the appointment of Regiment's Capital for transaction advisory services and support to Transnet on the 1064 Locomotive transaction, and sub 4, delegate authority to the acting GCE to approve all documentation relating to the confinement. Now, if I could take you please to page 387. Now we're dealing with the Regiment's Capital part.
That is 250.387.
250.387, paragraph 62. Transnet appointed Regiment's Capital, now we're talking about initially, as the transaction advisors on the 1064 Locomotive transaction. In terms of the aforementioned mandate, Regiment's Capital was required to advise on deal structuring, financing, and funding options to minimize risk for Transnet. It says at 64, regiments have been working together with the risk management stroke middle office of Transnet Treasury for over the last 12 months to achieve the outcome below. At 69, Regiments has assisted Transnet in negotiating with a number of potential Chinese sources of the ZAR funding for the ZAR syndicate loan facility, including, etc. And then at 73, of direct relevance. And that's at 250.388, the financial advice and negotiation support that Regiments provided through this entire process, which took in excess of 12 months, was done at risk, with an expectation of compensation only on successful completion of the transaction. And then at 75, given the invaluable contribution of Regiments to the successful conclusion of the transaction, Regiment's success-based fee will not exceed 15 basis points, and then the schedule reflects that that amounts to 166 million. Do you see that? And then in a similar vein, if you go to page 250.390, at paragraph 97, given the invaluable contribution of Regiments to the successful conclusion of the funding transaction, Regiments is due a success or risk-based fee of 15 basis points on yield payable by Transnet to JP Morgan or portion thereof, subject to a maximum of 166. And then the recommendation, perhaps just to repeat the third bullet point, approve the contract extension from 99.5 million to 165.5 million. So the difference between those two figures is 166 million. For the appointment of Regiment's Capital for transaction advisory services and support to Transnet. That you signed on the 28th of April 2015. Do you see that?
Yes.
Now, when this memo talks about the appointment of regiments and the work that it was initially required to do, can I just direct your attention, please, to an earlier document signed on the 4th of February 2014. That you find at page 250.380. And this is the third addendum for advisory services relating to the acquisition of the Locomotive tender. And you will see that it's between McKinsey and Transnet. But if you have a look at 382, it was signed by Eric Wood, titled Executive Director, Regiments Capital. And then it was signed by Mr. Singh on behalf of Transnet. It seems on the 4th of February 2014. If I could direct your attention to paragraph 3.1 at page 250.380, the deliverables for the revised scope of work as per clause 2 derived and agreed upon by Regiments Capital for executing the funding portion of the tender agreement outside the code. The objective of this work-specific project is to conduct all the necessary studies and preparatory work to enhance Transnet's ability to raise the required funding at a competitive interest rate and to achieve an optimal funding structure with minimal pressure on Transnet's funding liquidity. And then you'll see there's a whole lot of numbers where the deliverables are set out. For example, at 250.381, 7, evaluating all potential funding sources and mechanisms. And then in relation to the variation of the contract price, you see at 4.2 that the work performed for this deliverable will be fixed at a price of 15 million. So that is the third addendum, which was on the 4th of February 2014. Then we get the memo that you signed, which we've dealt with at 383. And now I want to take you to the next document, please. That you find at page 392, the recommendation that you made and your colleagues made to BADEC was then accepted on the 29th of April. This you find at 250.392. You'll see that at 393 it was resolved, and then the wording is the same as your recommendation. And then the next document I want to take you to...
Sorry, Mr. Chair. I've attempted to follow, and I'm sure Mr. Gama is not following, because he's referred to a document of which it appears Mr. Myberg's putting to him that was approved by him with reference to page 392. That's simply not correct. That's a letter addressed to whom it may concern. It appears to have been produced under the hand of one Buchle and Lovu. So I think you have to go back so we can get...
So may I just retrace my steps? What I meant to say, and I hope I certainly intended to, is that Mr. Gama and his colleagues made a recommendation to BADEC. Mr. Gama signed that on the 28th of April 2015. What you find at what you find at 250.392 is a certified extract from the minutes of the BADEC meeting. It was held the next day on the 29th of April. You go to 250.393, it's resolved that the committee approved the following, and of importance is the second bullet point: the contract extension for the appointment of Regiments Capital for transaction advisory services and support to the company on the 1064 Locomotive transaction from 99.5 million to 265 million. So what was recommended by Mr. Gama was then approved by EADC. That's 29 April. If I can then take you, please, to the document you find at page 250.394. This is a memorandum to you from Mr. Singh, dated the 19th of May. And what we see, if you could go, please, to page 250.398. Mr. Singh, a series of people who signed this memorandum in May. Mr. Weir on the 18th of May 2015, Mr. Peter on the 18th of May 2015, I think Mr. Singh on the 19th of May 2015. You signed some 2 months later on the 16th of July 2015. Will you accept that?
Yes.
And if you go to page 394, paragraph 1, the purpose of this submission is to request the acting group chief executive to approve the contract addendum to Regiment's Capital for transaction advisory and support services. So this flowed from your recommendation and the acceptance by the BADC. So the purpose of this submission is to request the acting chief executive to approve the contract addendum to Regiment's Capital for transaction advisory and support services on the 1064 Locomotive transaction. You go to page 250.395, you will see there's a discussion. Submission was made to the Transnet Acquisition and Disposal Committee detailing the services rendered by Regiment's Capital and the successful outcome. 7, the submission included the request for approval to extend the contract value. 8, the submission was approved in its entirety by the ADC. That we've gone through. And what you will see then at the end of this document at 398, under the heading Recommendation, it's recommended that the acting GCE approves the following. 1, the value of the contract be increased to a capped amount of 265.5 million, and sub 2, the allowance for the contract period to accommodate the successful conclusion of the funding and hedging agreements with CBD, that's China Development Bank, and JP Morgan in order to effect the remuneration in bracket success or risk-based fee to Regiment's Capital. Now, what I just want to point out to you is that it seems that before you signed this memorandum, which recommended, and the purpose was to request you to approve a contract addendum. Before you signed it on the 16th of July 2015, Mr. Singh, on the face of it, authorized the payment on the 11th of June 2015. Perhaps I could take you to page 250.399. You will see that at 250.400, there is an invoice from Regiments in the amount of 189, which 166 plus VAT gets you to 189, and that amount is a payment advice reflecting payment on the 11th of June at page 399. Do you see that?
Yes.
And you confirm that that's before you signed the memorandum at page 250.398.
That's correct.
And then what came after that was the second addendum. In other words, that was the contract that you were asked to approve and put in place. And that second addendum you find at page 250.306. .306. And if I could just take you to the end page of that, at 250.309, you will see, I'd ask you to confirm, please, Mr. Gama, that you then signed this on the 16th of July 2015. It was signed by you and it was signed by Mr. Wood.
That's my signature.
You confirm that?
Yeah.
And what this did is it put in place the contractual variation, correct? And it provided for the payment, formalized payment of the 166 success fee. You can go through it if you'd like.
Yeah, no, you're moving pretty quickly,
Okay.
and the words are very small.
Yeah, absolutely. Let's go through it if you'd like to more slowly. The preamble, I think, gives you a sense of what it is. 1.1, Regiment's Capital and Transnet signed the first addendum. Parties now wish to further vary the MSA, the normal sort of introduction. If you go to variation of conditions with paragraph 3 at page 250.307, it's incorporating the recommendation that you had made, it's incorporating the decision that was made by the BDSA. You'll see that at 311, the scope of the work shall be amended to include the following deliverables: technical support, development of a detailed funding plan, next bullet point, assist Transnet in the negotiations, assist Transnet in negotiating with a number of potential Chinese sources. So we're amending the scope of the work, recommending advice and assistance post-successful conclusion of negotiations, and then it goes on at 313 to provide for the success fee of 166 million. See that?
Yep.
And we know that you sign this and you concluded this contractual variation on the 16th of July, by which time Mr. Singh, on the face of it, has already paid Regiment.
Correct.
So, what I just wanted to ask you is a few questions in relation to this. Firstly, was it not irregular to have allowed regiments to work on this project without a contract being in place? The contract came afterwards, once the work was completed.
On the face of it, they are saying they'd allowed it, they'd allowed them to work on it for the previous 12 months. I was still fairly new in the group office here. I think it's one of the, it says April 2015. I think I arrived there around the 20th of April 2015. But so when you get there, people say these people have been working here for the past 12 months. Okay, that's what you get told. But appropriately, I think everybody would want to put the horse before the cart and have the contract in place beforehand. So that was that. But by going to the acquisition committee and informing them that this is what has happened, it also regularizes that, but it's a retrospective approval. It's being approved after the fact, when the actual work has been done.
You see, Mr. Gama, perhaps I could also just get your view on this. What we've seen is that regiments were initially appointed simply to be advisors. The amount that they stood to be remunerated was 15 million. What we've seen from the documents we've gone through is they went from being purely advisors to people that actually did the deal. They were deal makers. They executed this deal.
That's correct,
and
yes.
You say you were comfortable with that being regularized ex post facto?
Well, that is what the people who were dealing with it said they had done, and you've seen a very detailed memo that went to the PADC that we were reading just earlier on, that had 99 paragraphs, if I'm not mistaken.
Absolutely. Let me just take you to paragraph 73,
and
the one you've mentioned. Could you turn up page 1044? You've
page
250.388. You quite correctly pointed out that they were at risk, that they were allowed to work there without a contract for 12 months, doing something different to what they were contracted to do, and it records that they did so at risk. At paragraph 73, at page 250.388. So do I understand correctly that what that meant is that if you wanted to, you didn't have to pay them anything?
Well, if you read the whole thing, it says there was an expectation of compensation only on successful completion of the transaction.
Yes, but at risk.
So they've worked at risk for 12 months with an expectation of compensation only on successful completion of the transaction. So I guess at this point, they have now successfully concluded the transaction, and therefore that's why there's then the motivation for the actual payment.
But could you find any trace of a procurement event? I mean, this is a different contract. So they start off advising you as pure advisors, 15 million. They'll end up executing a deal, getting paid a success fee of 166. Can you find any trace of a procurement event in relation to the 166?
I don't know if you call it a procurement event, but if you go to the memorandum that I signed on the 16th of July.
Yes. Is that at 394, 250, 394?
At page 250, 394, correct. Yes. If you go to point number 5.
Point number 5 on the memo.
Yes, 250.394.
Okay.
Maybe to provide context, we started 3, but I'm not going to go through all of it. It just says, upon phase 2 of the engagement being reached, it was decided by McKinsey and agreed by Transnet that McKinsey would cede the role. So that's how regiment comes into being to start structuring the financial arrangement. So it was initially McKinsey, and then it was ceded. That's point number 3. Point number 4 then says, subsequent to the cession agreement, the contract period was extended by 12 months. So in whatever way that it would have been done, I was not there, so I don't really know how it was done, but that's what they say. And then in point number 5, Mr. Maybeck,
yeah.
It's indicated that regiments indicated to Transnet that their preferred operating model for such engagements is usually based on a risk-sharing model or a success fee. And then that number 5, the next line says, a submission was approved by the GCE on 17th of April in support of changing the remuneration model. The agreement was then amended by value to reflect a change in the remuneration model as proposed by regiments, and it says refer to Annexure C. It would be instructive if we went to Annexure C. Is it there?
Well, that we dealt with Mr. Malefe, because it was before your time. But can I ask you this?
So I'm saying that all of these things that appear to have been done were approved by the time I arrived there. So
fair enough. Can I just ask you one other question and for your comment? I mean, didn't regiments now have a conflict of interest? Because we've seen that they were appointed as pure advisors to advise, presumably independently, on models and options. And then what they ended up doing was actually executing.
Mr. Maybeck, I'm not qualified. You've made me read too many documents already in this thing, and I'm a bit confused now. So if you say they were appointed only to be advisory, I've seen another document, which is a session document, that says they will now do deal structuring. So I don't know in terms of the financial people, in terms of what their thoughts were and what the discussions were in relation to this. So I'm slightly underqualified, Chair, to comment on it.
So have you got any sense as to whether or not the fee that was paid to regiments was excessive? Are you able to comment on that?
I'm not able to comment on that either. What they say in that long memo is they try and give a formula that was used. So they say 10 PPS, 15 PPS, 20 PPS, and then here under 75. They say, given the successful conclusion of this transaction, the fee will not exceed 15 basis points on the yield as reflected in the NPV calculation. So that in itself is probably a manner and way in which they deal with these kinds of things. But I don't know if this is the norm, whether this is lower than the usual or whether it is higher. I'm underqualified to give an opinion.
All right. Well, I won't tax you on that, because some evidence has been led that the market convention and Transnet practice where lead arrangement fee was 6 basis points.
I don't know.
All right.
I wouldn't be able to.
You speak about, you've made reference to Mr. Mohammadi. Perhaps I could just take you to his affidavit. Could you please go to BB 3A? Can you turn up page 18? I just want to ask your comment on this. Paragraph 5.5.9. And Mr. Gama, I do appreciate that you've come in at the tail end of this. Page 18, paragraph 559. The Transnet Treasury team, says Mr. Mohammadi, had sufficient experience to enter into loan transactions without the need for external support. In my view, there was no need for the above-mentioned arrangement fees to be incurred. Do you have any comment about that? And what was your sense and experience of Transnet Treasury?
I wouldn't be able to comment. I think people who were in proximity to the Treasury team would be the people in finance. But in terms of reputation, as I understood it, is that Transnet also had one of the finest Treasury teams in the country in terms of reputation. So that I know, but I wouldn't be able to tell you, okay, what does that mean? What is it that they can do and what is it that they outsource?
You see, it really was to that Mr. Mohammadi spoke. And ultimately what he concluded on the CBD loan, he said it didn't make any commercial sense, and he reflected that, and I quote, "The only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments, ultimately for some entity that existed outside of the system." That was his evidence.
Where are you reading from?
I'm reading from page 144 of the transcript of day 93. This was his evidence. Perhaps I can read it again. The only possible...
it's something that's in front of you?
Yes.
Oh, okay.
So just bear with me for a moment. The only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments, ultimately, or some entity that existed outside of the system. Did you confirm that the Transnet Treasury was well equipped and was competent?
Yeah, well, that is the reputation that Transnet Treasury had, was that it was amongst the finest. But I wouldn't be able to tell you what they could or couldn't do. But a person of Mohammedi's stature would have been aware what it is that they can do, because he'd acted as a CFO from time to time. So he would know, and I think he had enough time preparing for this to have a look at some of those things. But the unfortunate thing about all of this is that we are trying to operate on a patient when something has already gone wrong. And he is now using hindsight. It would be good if he was there and he says, let us not have these types of transaction advisor. But he didn't say that when it was happening. And some of us would not have been the wiser whether or not it was appropriate or not.
So, is your evidence that based on your own understanding, knowledge of the skills, experience, and expertise that the Treasury team at Transnet had, you wouldn't be able to say how far they could go in dealing with different transactions, but based on what you used to hear or read about them, your understanding is that they were one of the best Treasury teams in government.
Yeah.
Yes. Okay.
Just to add to that, Mr. Gama, if you go over the page 19, paragraph 5.5.11, Mr. Mohammedi says, my opinion is supported by the then Transnet Group Treasurer, Ms. Makhatho, who wrote an email on 21 August 2014 to Mr. Molefe and Singh pointing out the risks of allowing an external party to negotiate a significant new loan agreement in isolation of the implications it may have had on our existing debt book. Ms. Makhatho further pointed out that in her view the pricing of the loan was out of kilter, especially due to the fact that it carried the security of liens over the locomotive asset. At the time, she estimated the excess cost of the debt to amount to 3.7 billion over the term of the loan. And then the email is attached. You want to comment? I mean, did you, during your tenure as the GCEO, acting GC, did you interact with Ms. Makhatho?
No. I knew Ms. Makgato when I was the CEO of TFR. By the time that I became the acting GCE, it was Ramos Abudi that was the treasurer. So my interface with Ms. Makgato was as CEO of TFR. I've never interfaced with her as the acting GCE.
Just going back to the concerns that Mr. Mohammadi expressed in his evidence, that he thought there needed to be probably some kind of ulterior motive. I have put to you earlier in your evidence what the money flows investigation has revealed in relation to this payment of 189 million. And you'll remember I put to you that the investigation has revealed that 147 million of that, 78%, was paid to Albertine, with 122 million then having been laundered onto Sahara Computers.
Yes, that's what I think. Yeah,
You recall that?
I think you've said. Yeah.
Well, the memorandum, I think we looked at a little earlier, which I can't remember whether it was appointing or just ceding the rights from regiments to trillion. But I would have thought that where you were asked by people under you to sign a memorandum recommending the appointment of outside advisors, you would first want to know why do we need them? Don't we have this expertise internally? Is there something that you may have raised with people within Treasury?
No, Chair. You know, at the beginning of time, and people in transit will tell you, I don't like consulting. If we can do things without consultants, that's what we do. In fact, when I left Transnet, I had set up something that I call internal consulting. People who actually work for Transnet and who can go around using their expertise, troubleshooting in different entities. In this instance, you get told that the people have been here for 12 months. They've been working, so you have to assume that they are relevant. Because why would you keep them for 12 months? But also, there's something that we are doing here that we need to clean up a bit. There's an interchange of words. So you would talk about Regiment's advisory. It's a different entity from Regiment's capital partner. We talk about Transnet, trillion asset management. It's a different entity. But I think everybody gets wise up afterwards to then say, oh, okay, it's not the same entity. There's a number of these entities. So advisory is the one that was doing GFP, as I understood it. That was advisory. But the one that is structuring is capital partners, whatever the name that is reflected here. So it's different entities. So we mustn't make the mistake of thinking the advisors have now been appointed as deal structuring. It doesn't appear to me that that is what that was the case, but it's different entities. But I think when Mr. Singh is here, you might he might be much more clearer than me in terms of these distinctions between these entities. But I can just see it that sometimes we conflate Regiment's advisory from Regiment's capital partner.
Mr. Martha?
Yes, perhaps I could just point out one thing to you. If you have a look at page 380, the third addendum, where Regiments is appointed as an advisor.
380 of the previous file.
Yeah, 250.380. There you will see that it's Regiment Capital, Pty Limited, that we're talking about.
Yeah.
At
Is
382.
that in the other bundle?
382.
250.380. So the original appointment as advisor.
Sorry, Mr. Mybeck. I think, is that in
Bundle 7.
bundle 7? Page 250, point
380.
387 or 380?
380. You'll see that the original variation, you have a look at paragraph 3.1, relates to Regiment's capital. And you'll see at 382, it's signed then by Eric Wood, Regiment's capital. The agreement that you entered into to regularize the variation of the contract is at 306, and it's also between Transnet and Regiment's capital. See that at 306?
Yes, Regiment's capital. So that is like for like. So this is the entity that is dealing with the financial structure.
Can I ask you, were you surprised that now that you see, or did you know that Mr. Singh had paid Regiments before you signed the memorandum?
No, I just saw it now. I think you.
Is it of any concern to you?
Yeah, it's concerning. There's one of two things. The first memo, the long one, it was to go to the board to get approval. So the board approved it. But in the approval of it, the delegation was to the GCE in terms of authorizing the payment. So the signing of it before the GCE approves it is irregular.
Can you think of any reason what would have motivated him to do that?
No, you're going to have to ask him.
And you would not know of any circumstances that would justify that?
No. It wasn't told to me. There's nowhere where he says, look, sign this, but I've already paid. There's nowhere where he says that.
I'd like to then move to a different topic, and that is the procurement of the 95 locomotives. Just give me a second, please.
Which bundle are we going to go to?
going to deal with the two files together, but if I could ask you, Chairperson, to go to the POI bundle, bundle 6.
Yes.
I have just a few questions for you in relation to the 95 locomotives. I take it you will recall, and this is dealt with in the Fundutsi report, commencing at page 36, Chairperson, of bundle 6. I certainly don't intend to take you through all of that, Mr. Gama. I just want to ask you one or two questions, if I may. I take it you'll recall that in 2012, CSR was appointed as the preferred bidder for the supply of the 95 locomotives. Is that correct?
Yeah, I don't know the dates, but if you say it's 2012, you can maybe just refer me where you are reading.
We can go through all of this in a moment. And can you remember what the costs were, costs of those 95 locomotives were?
No.
If you go to page 93, just to get to the date, page 93 at paragraph, and you know these paragraph numbers are very long, 5.5.18.44, according to a letter dated 5 September from Malefe to Pan, Transnet notified CSR of its appointment as the preferred bidder. In the letter, CSR was requested to sign the agreement by no later than the close of business on 6 September 2012. See that?
Okay, so that was the date, yeah.
Now, I just wanted to ask you please to turn to page 39. And of course, like so many of these things, we start off with presentations being made to the BADC. You see there's a heading at the top of 39, BADC of 3 August 2011. Just wanted you to confirm that in 2011, Mr. Sharma, you can recall, it's listed here, was a member of the BADC and a director of Transnet.
Yes, I can confirm that.
The evidence before the Commission is that he was then appointed as the chairperson of the BADC in the following year, in August 2012. Does that accord with your recollection?
I wouldn't know the dates, but he did become the chair of the BADC.
In 2011, it reflects that Mr. Mkonazi, or do you know who the chairperson of the BADC was in 2011?
Yes.
Who was it?
It was the late Bongani Don Mkwanas.
Don Kwan.
Is my understanding correct that his name was spelled with an H as opposed to the one
Yes,
of
that's
the
correct.
other Mkwanas, which was spelled without an H?
That's correct, yes.
Okay. So the spelling at age 39 would not be correct
That's,
without
yes.
the H.
Yes. Yeah, it needs to have the H.
Yeah. Okay.
Were you involved in the negotiation of the 95 locomotives?
No, not that I can remember.
I think I've put to you that the money flows investigation reveals that CSR and Regiments Asia, represented by Mr. Esser, entered into a BDSA in respect of this acquisition, with Regiments Asia being due a 20% commission or kickback. And their investigation has also revealed that some $17 million have to date been paid by CSR in respect of this acquisition.
No, I'm not aware of it.
So we're going to come back to this, I suppose, in more detail when we deal with the 1064. But Mr. Gama, with your experience, I suppose something that the Commission needs to consider and investigate is how, if negotiations are done bona fide, how is it possible that there's enough in the pot to fund a 20 or 21% commission on acquisitions of this size? And these 95 locomotives, the contract price was some 2.5 billion rand. Do you want to comment? Perhaps you can share with us your insights into that.
No, I wouldn't be able to comment on that. I'm not familiar with that. But from what I understand from some of the experts, the margins on some of these locomotives, they are no more than about 4%. That are made by the OEMs as a global standard. And the CSR that you talk about is amongst the cheapest of the locomotive manufacturers. So I don't know how possible it is that you could then say there is money flows of that nature from these contracts. I don't know.
Well, not if the negotiators are doing their job properly.
No, what I'm saying is that from the negotiations and from comparisons that I've seen, they have been amongst the cheapest of the locomotives. It might just mean that maybe the costs could even be lower, but I think when people are confronting the issue, they would see that there isn't anyone who has charged us lower than them in terms of locomotives. So to then say that there are also commissions of the nature and the magnitude that you indicate, it baffles my mind.
Right. The last thing I just want to deal with briefly is the BE requirement was waived in phase 1 in this tender evaluation process. Are you aware of that?
Yes.
Can I take you please to page 81? If I could ask you to go to paragraph 5.5.16.26, I've just got one or two paragraphs to take you through here. In their recommendation to Molefe, Gama and Gianni, recommended option 2 on the basis that option 1 would mean that foreign lenders did not have local representation, were prejudiced and scored 0 on triple BEE. And says they further indicated that option 1 did not support the BBEE Code of Good Practice clause, which allows for such foreign companies, if registered locally as startup enterprises, to be deemed to have triple BEE contributor status of level 4 contributor in the first year of operation. And then the next subparagraph says, the notion that foreign companies were prejudiced cannot be substantiated in that Nalesco, a South African company, scored 0 points on triple BEE. We determined that the recommendation by Gama and Gianni to Malefe to amend the evaluation criteria to exclude triple EEE. The request was approved by Malefe on 8 June. Next subparagraph, we determined that after the conditions were changed to remove the triple EEE requirement, CSR scored overall 69%, above the minimum threshold of 60%. And then perhaps I could just ask you to comment on paragraph 5.5.16.30. Based on the reasons advanced for the decision to exclude triple EEE condition from stage 1 process as reflected above, we determined that CSR was the only foreign entity that benefited from the said decision. Do you want to comment on that?
Yeah, I think that the problem with some of these reports by people such as Fundutsi is that they are misleading and they will misrepresent the meaning of things. Because I think they don't understand some of these processes. And then they will reach conclusions that are very wild. The fact of the matter here is a very simple one. And it affected all the tenderers. To evaluate BEE at stage 1 or stage 3, if you do it for all of the entities, it means nothing. It's meaningless. There is no change. It doesn't change the price of X. But here, you get the kinds of tick box auditors, even that, auditing 101, you don't even just do tick box, who will then come here and give this commission an impression that something went wrong by agreeing not to evaluate at level 1, but evaluate at level 3. All of the entities were evaluated at the same time. All that happened here is they said, when we went out on tender, we assumed that every entity that is going to tender already has a triple BEE certificate. But we were wrong. Because we have foreign entities who are in the process of creating their South African entities. So can you allow us not to evaluate any of the entities? And then they used the example of the foreign entities, and they said these two, for instance, would be affected by this. It means that they would drop off. But we will still evaluate triple BEE. Let us allow them to establish their local office. Let them then go to the, not rating agencies, what do they call it? There are BEE agencies that that give people a certificate which tells them whether they are 100% compliant or they're at 50% or whatever. Let's then allow them to do this. We will then, at stage 3, evaluate all of the entities for their triple PE credential. So that is what happened here. Nobody lost any hair or anything as a result of asking for that. But also, in addition to that, the delegated authority, which was the GCE, could consider this and decide on whether it makes sense. But not only that, you then also go further and you inform the board that in terms of the criteria, this is what we said we will do. We didn't do this at level 1, we did it at level 3 because of this. There isn't anything sinister or anything that that was done. Each of the entities was evaluated in stage 3. If at stage 3 the entities did not have the necessary PE, then they would fall off. So everybody gets evaluated on a similar thing. There's nowhere where, as a result of not evaluating PE at stage 1, you are advantaging anybody over anyone. It does not arise.
I think the question that I wanted to ask you is, you accept that CSR was the only foreign entity that benefited from that decision?
According to this, there was NELESCO and CSR. I don't know where NELESCO came from, but this is something that the cross-functional team said.
Sub 27 says the notion that foreign companies with prejudice cannot be substantiated in that NELESCO, a South African company, scored 0 points for triple BEE.
Well, they would score 0 points on triple BEE if during the time frame that they've been given they are unable to come in and provide the BE certificate. Or if their BE certificate comes in and says they're not compliant. So that's all it is. So their scoring 0 points is because of them not complying. It's not because they were evaluated at stage 1 or stage 3. So the issue here of which one is foreign and which one is not is really just neither here nor there. All that was happening here was the cross-functional team says we did not take into account that we might receive bids from non-South African companies. So instead of evaluating triple PE as stage 1, let's evaluate everything else except triple PE. Let's evaluate it at stage 3 to give them time. So if NELESCO, after being given time, still could not comply with the triple PE, then they would be scored 0. The same with the CSR itself. If after being given time, it doesn't comply with the triple PE, it gets scored 0. Everybody gets scored on one scale. They don't use different ways of scoring this entity. So for me, it's really, we're going to get into an argument and have a discussion which is really about nothing.
But what was the policy in terms of whether BE should be taken into account at the first stage
So the policy was
Or
that
what was the legal requirement as you understood it?
it's not a legal requirement.
It was a policy requirement.
It's an evaluation criteria.
Yes, but does not come from the policy.
Yeah, no. It's an
Where does it
evaluation
come from?
criteria where you say to everybody, as they take the documents, this is how we're going to evaluate you. And then you come in and then you say, here is a bidder, through no fault of their own.
No, hang on. Let's establish the rules. There were criteria that were set from
Yes.
the beginning.
Yes.
Is that right? The criteria included BEE. Is that right?
Yes.
Did the criteria that were required to be implemented before it was discovered who had BEE, who satisfied and who didn't satisfy, was the requirement that criterion of BEE should be a factor at stage 1?
Yes.
That was the position.
That was the position.
Okay. And then what happened was that at a certain stage, that was changed, and it was decided that BEE as a part of the criteria would be applied at stage 3.
Yes.
Is that right?
Yes.
And you say that was based on what? On the fact that some of the companies were foreign companies?
Yes, so the cross-functional team says, here's our RFP. As Transnet, we did not foresee that there could be entities, there could be foreign entities who do not have a local domicile. They then say, this is the criteria, we understand it. They then say, we think it would be prejudicial for entities who are just coming into the country. And they say, such as NELESCO and CSR, to evaluate BEE at stage 1. They are still setting up their offices. We will evaluate BEE in the same manner that we evaluate it. We don't change the rating, but the PPM, which is the Transnet Procedures Manual, it allows the person who has the delegated authority to consider this and say, does it change the price of eggs? Will there be anybody who is going to be prejudiced as a result of this? No. We're going to evaluate all entities at stage 3. We're not changing the criteria. We are still going to evaluate BEE, but we're not going to evaluate it at... so there are 6 stages of this thing. So the entity will still fall off if it doesn't comply. But at Transnet, you are allowed to approach the delegated authority to say, can we move this from stage 1 to stage 3? And that is what happened here. So there's nothing that changed. The criteria remained the same. All of the bidders were evaluated at stage 3. So I'm saying here, Chair, that we can talk a lot about these things. There was no one who was being prejudiced.
Yeah, no, I understand. You have made the point. Mr. Mybeck will pursue his questions. On the face of it, my immediate reaction would be, unless one was talking about a situation, about certain exceptional circumstances, I would have expected that if I'm Transnet and I say these are the criteria that are going to be used to determine who actually gets this contract, the fact that somebody says, oh, I just registered my company yesterday, so give me a chance to go and register this or get that certificate is neither here nor there, hard luck. If somebody says, I'm coming from France or whatever, I didn't know about what the requirements in South Africa are, hard luck. If you want to do business in South Africa, if you want to get contracts in South Africa, familiarize yourself with what the requirements in South Africa are. That would be my immediate reaction. But it may well be that when one looks deeply, it might change.
Yeah. No, here's a group of people who are exercising their minds. They are saying, we've put this RFP, perhaps we did not think properly about this thing, that there could be foreign entities who are not domiciled in South Africa. Because there are foreign entities. Most of these entities...
They must familiarize themselves with South African situation.
Yeah, but when people are coming through for the first time, you can give them that. The cross-functional team, they thought through this. It's not something that they just... they thought through it, they looked at options. And then they said, okay, we think this is a better option. And then they then said, can we take it to the delegated authority to look at it? And then the delegated authority could then agree or disagree. But if the delegated authority can see that there's no one who's going to be prejudiced as a result of evaluating, we're not saying we'll not evaluate BEE, we're just saying we'll not do it on stage 1, we'll do it in stage 3. And then that's what happened. But if you would rely on Fundutsi type reports, there's a lot of things that you will find here which just says that, you should be a robot, you mustn't apply any logic in terms of dealing with things, and that's not the right way.
Mr. Maybeck?
Yes, thank you. I'd like to turn to the 100 locomotives, if I may.
Yes.
And I just want to present something of an overview before I get into Mr. Kellard's affidavit and your response. You will recall, Mr. Gama, that CSR, are we talking about the 120E electric locomotive? You'll recall that CSR was awarded the tender on Confinement, replacing Mitsui. You remember that?
Yeah, I just want to go back. Can you just remind me where is my
I'm going to come to your affidavit.
yeah, can you point me?
But let me take you to the page, if you want.
Yeah.
Bundle 6, page 140.
Page 140.
Yeah.
It's just useful that we... Okay.
So I'm just presenting an overview. If you go to the middle of the page, 5.6.18, Sub 1, as indicated above, we determined that the board approved a confinement of 100 locomotives to CSR on 24 January, estimated cost of 3.8 billion. We determined that Molefe concluded an agreement with CSR on 17 March for the supply of 100 locomotives at a cost of 4.38 billion. Do you see that? Do you see that?
3.8, yeah.
Now, are you in a position to confirm, because again the timeline here becomes important. This LSA was concluded on the 17th of March 2014, which was the same day as the LSAs were concluded in respect of the 1064 locomotives. Do you remember that?
Yeah, I wouldn't know on what date. I know that the 1064 was on that particular date, but I can't remember that there was any other on the same day.
Well, let me take you to page 183. Now, this is a section dealing with the 1064. And we'll come to one of the agreements in time. I'll actually show you the one concluded by CNR. But at paragraph 5.9.12.2, we determined, however, that by that time, and that's dealing with the increase in the ETC, the locomotive supply agreements had already been signed on or about 17 March 2014. So at least on that, the 100 locomotive LSA and the LSAs in respect of the 1064 were concluded around about, either on the same day or around about the same. Do you have a recollection of that?
No.
Just by the way, Mr. Gama, you didn't sign the LSAs. From what I've seen, they were signed by Mr. Malefe and Mr. Singh. Would that be correct?
What do you refer to as the MSA?
The LSA, the actual locomotive supply agreements concluded in relation to the 1064 locomotives. I'm just simply asking, you didn't yourself sign that?
Yeah, that's why I don't recall what the dates were. Yeah.
All right. Now, at this time, in March 2014, Mr. Sharma was the chairperson of the BADC.
It's possible.
And the director of Transnet. Is that right?
It's possible. I can't remember when their term expired.
We'll come to some documentation in due course. Yeah. And then I think I've put this to you already. Mr. Issa, representing on the money flows investigation, representing Regiments Asia, concluded a BDSA, again with CSR, for a 21% kickback. To date, payments of $124 million have been made under that BDSA and the one in relation to the 359 electric locomotives that were part of the 1064.
Sorry, can you repeat that?
Mr. Essa, on behalf of Regiments Asia, concludes a BDSA with CSR for 21% kickback in relation to the 100 locomotives. To date, $124 million have been paid under that BDSA and the BDSA that he concluded in relation to the 359 electric locomotives that were part of the 1064 contract. Do you want to comment on that?
Sounds like a telephone number. 124 million.
$124 million.
In respect of the 100 locomotives.
The 100 locomotives and the 359 electric locomotives.
Or a combination?
Yes.
No, I don't know anything about it. I'm hearing it from you.
Maybe we should take some break. We've just gone past 7:45. Let's take a 10 minutes break.
Thank you, Chair.
And then we'll continue.
Chairperson, could you give us a sense of how deep into the night you'd like to go so we can make our plans, and also I can look and see what I can finish sensibly in that time?
Let's do that. From your side, how far are you from finishing with Mr. Gama?
I'm still some way. What I would like to try and achieve this evening is to finish at least 100 locomotives.
Yes, okay. I can go for quite some time. From my side, we can just go. We can go to 9. We can go beyond 9. I must just check with the staff and technicians. From your side, Mr. Gama, you are fine.
I must just check if my team has got the tank to go beyond 9 o'clock.
Okay, all right. Your counsel is fine.
Mr. Chair, we understood that we would run until about 8 o'clock. I see it's now 10 to 8.
Yes.
Regrettably, we also have other commitments. Is it possible, because we'd like to make those arrangements, I'm under pressure with papers that have to be filed elsewhere and so forth.
Yes.
Is it possible that we proceed until 8:30?
The only difficulty is we need to finish by tomorrow with Mr. Gama's evidence. If the position is that we should be able to finish tomorrow, then maybe there might be no problem. But I think one should first have an assessment. I think Mr. Mybeck probably won't finish today, or it depends. Well, what can you say, Mr. Mybeck? Because when we have an idea when you might finish, whether it's tomorrow after another hour.
No, it's going to be some time, Chairperson. I mean, the only comment that I wish to make is that, I mean, I think that we must obviously finish tomorrow. So if we're only going to go until 8:30 tonight, then I suppose we must commit ourselves to going on for as late as we have to tomorrow night.
Yes, because I think the bottom line is we must finish tomorrow. So because we just don't have the time, we are close to the end of May. So I don't know, in the light of that, and maybe bearing in mind how much time you might need for re-examination, if any, after Mr. Mybeck, what is your assessment?
Mr. Chair, there's certainly going to be a need for re-examination.
Yes.
There is, of course, a discussion that has ensued between Mr. Myberg and myself. In relation to that, it was suggested that we consider whether we don't file a further affidavit.
Clarifying certain things.
By Mr. Gama that deals with those issues. It's not a matter that we've had sufficient time to consider. It was in fact suggested this afternoon.
Yes.
But to come back to the conclusion of his testimony in chief, if I may term it such.
Yeah.
We're also available to start earlier tomorrow. We only started after 5 today, but we can do much earlier tomorrow if that is needed.
Oh, is that so?
Yes.
When you say much earlier, what do you have in mind?
I have other commitments from about 6 o'clock tomorrow morning, but certainly by midday, I would have dealt with those matters, and we can start by about 12 o'clock, I would imagine, subject to my client's availability.
Yes, well, of course, tomorrow I have got a day session. The Inspector General is giving evidence tomorrow. That's meant, I think, if I recall correctly, to be the whole day, but he might finish before 4 o'clock. So at this stage, your sense of how much time your re-examination might need would be what?
At least an hour and a half to 2 hours.
At least an hour and a half. Okay, Mr. Mybeck, can we go at least up to 9 today?
Yes, Mr.
But of course, if we stop at 9, because from my side we could have gone even up to 10 and so on, then tomorrow it would have to be, the arrangement would have to be that one, you are able to be here earlier than 4 o'clock, not on the guarantee that we would start earlier, but on the understanding that if we finish earlier with the day witness, then we can start. but that we would then go on right into the night to try and finish. Would that be fine?
As you please, Mr. Chair.
Okay, Mr. Mybeck, maybe we could go up to 9 today and then
Push through tomorrow.
yeah, and then tomorrow. And I think what would, when we adjourn this evening, we could talk about what time everybody could be here tomorrow.
So I think that, DCJ, is very important to try and make an accurate assessment of that, because
Yeah.
you know, if we have to come here and kick our heels, it's not the most efficient use of time. And perhaps
Yeah.
we could be on standby, and then your registrar might
Yes,
tell us.
no,
Because once you travel here,
Yeah,
there's very
yeah.
little you can do.
No, I think that could be done, particularly if all parties are not too far from here. So no, that could be done. I think by lunchtime we would have an idea. Mr. Pretorius will be leading.
Yes.
Dr. Dintwe, we would have an idea, and then maybe you could make contact with Mr. Pretorius, and
At
he could give an
lunchtime.
assessment,
Yes.
yeah. And then you could share that with counsel for Mr. Gama.
Mr. Chair, might I then work on the assumption that we're not going to deal with re-examination tomorrow, given the submissions by Mr. Myberg, and that will have to be held over some other date, alternatively that be incorporated in a further affidavit by my client?
Two matters. One, I would like us to try and finish tomorrow. When I say finish, I mean finish all oral evidence, including re-examination, if there is re-examination. That's point one. Point two, if I understand you correctly, what you and Mr. Mybeck have started talking about seems to coincide with an idea that I've begun to have in regard to other matters where there are challenges in terms of time, in terms of re-examination. If the discussion between the two of you is that instead of having oral re-examination, an affidavit could be finished which would clarify whatever matters need to be clarified, because the regulation says the purpose of re-examination is to clarify, then I would have no problem with that. So if tomorrow we are done, but there's no time for re-examination, but there's an agreement that such an affidavit can be finished to clarify whatever you would have wanted to clarify in re-examination, that would be fine with me.
The only added difficulty to all of this is, of course, the issue concerning Mr. Todd's
Yes.
application for cross-examination.
Oh.
And so I need to consider it in that context.
Yes, yes.
So there's much to be considered within a very short space of time. And that's why I'd like to know whether we require tomorrow to present the re-examination or not.
Okay, no, that's fine. But my recollection is that the issue relating to Mr. Todd was a very narrow issue. That's my recollection. So if it remains a big deal, I know that we said, let me hear Mr. Gama's evidence, and then we can see how much dispute is left after that. I'm sure that if that's all that's left, we could discuss and find a way.
As you please, Mr. Chair.
Okay,
Thank you.
All right, so let's just take a 10 minutes adjournment now, and then we will return. We adjourn. Yes, let's continue.
Thank you. I'd like to carry on then with the 100 locomotives. Can I just ask you, Mr. Gama, so you've explained to us the role that you played in the 1064 transaction. What role did you play in relation to the 100 locomotives, just broadly speaking?
It's a bit of a long time ago.
Would it have been the same or different to the 1064?
I think this one was a confinement.
Yeah.
Of the 100, they relate to the coal line. When you say broadly speaking, that's a bit too broad, but I remember that there was a confinement that we tried unsuccessfully to do through Mitsui, and then, yeah, it was really around taking the presentations to the Group Executive Committee, and then being on standby if one is required for the PADC meeting.
So, Mr. Gama, what I'm going to do is I'm going to ask you to turn to Mr. Callard's affidavit. This is Exhibit BB4, little a. BB4A. So, in dealing with the 100 locomotives, the key part of it is the sequence of events that Mr. Callard sets out from page FQC 106 through to through to 13. Now, what we've seen from your affidavit is that, I mean, a lot of this is common cause between you and Mr. Callard. But perhaps I can just run through this. He says at paragraph 26 that I prepared the first business case in April and a revised business case in July. Further changes were...
I'm sorry. What is the page? I'm at 106.
That's it. Page 6.
Page 6.
Chairperson, yes.
Okay, all right. I've got it.
So in dealing with 100 locomotives, he says he prepares the first business case. At 26.1, he says in September, October, I was requested by Gama to update the memorandum to the BADC for an additional 119E type equivalent electric locomotive. The memorandum dated 15 October 2013 was signed by Gama and others. At 27, the said memorandum recommended confinement to Mitsui and Company Africa Railway Solutions, a subsidiary of Japan's Mitsui and Company Limited, on the basis of 1, compatibility with the existing 119E type locomotives used on the coal export line. 2, availability of facilities without having to establish new facilities. 3, saving in design, testing and type approval, and fastest possible delivery. And then he's at paragraph 29. He says that 19E type locomotive is a heavy haul locomotive, specifically intended for use on the coal export line. Goes on to explain that. He says at paragraph 30 that the memorandum specifically stated that the E20 type, i.e. 95 locomotives, the one we spoke about, recently awarded to CSR was not suitable as it's a general freight locomotive of 22 tons per axle. At 31, further, the memorandum also stated that the CSR 90E type locomotives still had to be tested, and only thereafter would it be possible to say to what extent it could replicate the heavy haul capabilities of the 19E. Furthermore, an extension of the 95-20E contract would not be acceptable procurement mechanism, as it would entail a material design amendment that could be challenged per the procurement procedures manual. Then he goes on to say at 32, I was informed through an SMS from Gama on 21 October that the Group Chief Executive, Mr. Molefe, had withdrawn the memorandum at the BADC meeting on the same day. And then at 33, on 22 October 2013, I sent an SMS to Gama requesting direction on the way forward. Gama replied via SMS as follows: I believe it remains withdrawn. I'm now trying to see how we can get lease locomotive from Queensland. GCE just said to me, if I need anything, it must be less than $1 billion if it's capital, and for a confinement, it must be within his authority. Then he says, at 34, I later prepared an updated version, which Gama signed on 25 November 2013. On the afternoon of Friday, the 18th of January, I received the following SMS from Gama. Then he sets that out. You go to paragraph 38. On Monday, the 20th of January, I mailed a PDF version of the revised business case to Gama. 39, on the morning of Wednesday, 22 January, I received a mail from Molefe from Supply Chain Services requesting my assistance in formatting my memorandum of the previous Monday. When I perused the memorandum, I noticed that the memorandum had been changed to give effect to confine and award to CSR for 100 electric locomotives. And then at paragraph 40, he says a comparison of my original business case of 20 January with that received from Molefe revealed that the business case had been materially amended inter alia. You see at 40.2, the motivation to confine to Mars.
Sorry, Mr. Myberg, could you arrange for me to get, I think there are 2 pages missing here.
I beg your pardon.
Yeah, I don't have pages 9 and 10, which would be, yeah, I don't have pages 9 and 10. So the paragraphs you are reading, I don't have, but they can be inserted later on. I'll just listen to.
All right, thank you,
to you. Yeah.
So he undertakes a comparison between the 2 business cases. He comments inter alia that the motivation to confine to Mars, Tsui, had been removed and replaced with a confinement to CSR. At paragraph 42 at page 10, he says he was taken aback by these unilateral changes in the memorandum. He says at 43, as the prime author of the business case stroke memorandum, I was not consulted. And then at 44, he says he deliberated long and hard on Wednesday evening on the implications of what I'd learned. On Thursday afternoon, 23 January, I emailed Gama and Gianni expressing my concern at the unilateral change to the business case stroke memorandum I submitted on Monday in respect of the 19E type heavy haul locomotives to an unspecified general freight locomotive confined to CSR. At paragraph 45, my mail, this is at page 11, my mail to Gama and Gianni opens with, quote, "This is a difficult mail to write. in helping to format a recent version of the 180 locomotive business case on Wednesday 22nd, I noticed that the case was changed from that which I had submitted on Monday. This mail is because of the nature of those changes and implications. The implications are technical, and in the rationale for the acquisition, which was speedy delivery to mitigate MDS volumes at risk. And at 46, the essence of my comments inter alia covered the following issues. And then at 48, he says that during the preparation of my statement, the Commission provided me with 3 pertinent emails from which it is evident that Gama, Singh and Molefe had acknowledged my concerns per the email trail below. Sub 1, the first email was sent from Gama to Singh late on 23 January, essentially reflecting my concerns. It reads, quote, "Hi, Mr. Singh, I'm afraid the submission of the 100 locomotives is a mess and will need to be withdrawn. The 20E locomotive is a 22-ton per axle locomotive suitable for the GFB, while the 19E locomotive is a 26-ton per axle beast suitable for the coal line. The 2 locomotive types are not interoperable. While CSR can make additional locomotives in China in a very short space of time to mitigate against MDS volume loss, this would be counter to our localization strategy and would have to be spelt out. The 85 locomotives to be assembled by TE has not yet commenced, so we cannot yet make any argument that this would reduce the risk." At sub 2, the second mail was from Singh to Gama on the morning of 24 January saying that we would discuss the matter this morning. Sub 3, the third email, also on the morning of Friday 24, was where Singh forwarded Gama's mail to Molefe for information. Then we get to the BADC meeting on the 24th of January. The minutes of the BADC meeting on 24 January record the attendance of Molefe and Singh and the partial attendance of Gama and Gianni. The BADC discussed the acquisition of the 100 class 19E electric locomotives. The BADC pack containing the revised submission was signed by Singh and Molefe. The minutes do not reflect that the BADC was informed of my concerns raised in the email correspondence above. At 51, the minutes reflect that the BADC was misled by management as to the validity of the confinement process by 1, creating the impression that the 26-ton heavy haul CSR locomotive existed when in fact this was not the case. 2, using Chinese manufacturing facilities to motivate for the speedy delivery which would have negated local content requirements. See Gama's email in this regard. 3, reporting that the confinement was in compliance with the procurement procedure manual when no previous product existed. 52, it was accepted that the locomotives could or should not be confined to Mitsui, then the correct procedure would have been to go out on open tender. 53, the 100 locomotives were confined to CSR. And then at 54, on 4 February 2014, I received an SMS from Gama in response to my email of 23 January stating, "I've just seen your email. I would explain to you the GCE's thinking. This was not followed up," etc. So that's the kind of broad architecture and sequence of events. Now, as I mentioned to you, Mr. Gama, much of this is you don't take issue with, and you provide your own exposition over the space, I think it's of 8 pages, and I'm going to ask you to go through that. You'll find your response to what I've taken you through at bundle 7, page 250, page 250.150. This is from your third affidavit. So you start off at paragraph 42, add paragraph 26, and that deals with the original business case, a stroke memorandum. You say it's correct that the memorandum dated 15 October was in fact the memorandum that was submitted to the Transnet BADC for the acquisition of the 100 class 19E electric locomotives. The acquisition was to serve the coal line. Do you confirm that?
That's correct.
You go on to say at sub 2, it was my role, not that of Callard, to review the motivation and the approval of the business case. However, my role was limited to submitting the business case to the GCE of Transnet, whose function it was to submit the business case to the BADC. In turn, it was the BADC's function to submit the business case to the board for final approval. Is that correct?
That's correct.
And you go on to say then that the board was required to submit the business case to the minister for approval. Is that right?
Yes, in the event that PFMA approval was required. Yeah.
And you say in this regard, for me to attend BADC meetings, I had to be invited by the GCE to support him when he presented the business case if he found it necessary. Is that right?
That's correct.
So we know that you weren't a member of the BADC.
Yes, I was not.
And you go on to say in response to paragraph 32, you say it was strange for Callard to simply invite himself to the BADC meeting, this in circumstances where he hadn't been requested to attend such meeting.
Where he had not.
He had not, I beg your pardon. In many instances, I would invite him to attend a meeting so as to support me, and me in turn supporting the GCEO. Is that correct?
That's correct, yes.
Then I want to take you, if I could, to your paragraph 49. Add paras 44 and 45 of Callard. And what Callard is dealing with there is the change in the memorandum. You say at 49.1, the changes to the memorandum were effected by Singh, who signed the memorandum on 21 January 2014. The memorandum was then signed by Brian Molefe on 22 January 2014. It should be noted that my signature was not appended to FC14. I was not a party to what is alleged to have been the unilateral amendment. It was at all times known to Callard that I supported the confinement to Mitsui and Company. Would you confirm that?
That's correct.
Now, Mr. Gama, before I go further into your affidavit, could I ask you, please, to go back to bundle BB4A, and could I ask you to go to this memorandum, changed memorandum, which you find at page 244.
What's the page again?
244, Chairperson, that's FQC 244.
Got it.
And you'll see that it's signed at page 267. I think that's what you're referring to at your paragraph 49.1, signed by Mr. Singh on the 21st of January and then signed by Mr. Molefe on the 22nd of January. Is that correct?
Yes.
So perhaps I could just stop here and ask you, I mean, how on earth does this come about? Mr. Kellogg works on the memorandum in a business case. You are the business owner. These locomotives are for the use, presumably, of TFR. How does from one day to the next this memorandum change so fundamentally, or the confinement change so fundamentally from Mitsui to CSR?
No, thank you. From what I recall, I think as Khaled has indicated to you, sometime in October or November, the submission had been withdrawn from the PADC. Ostensibly because we had already confined to Mitsui, I think at least 2 times. And this would have been the 3rd confinement. So it was felt by the PADC that this would not be correct, and that I had been, persisting with this Mitsui, and this was the 3rd submission. So it appeared that the PADC rejected my proposal on that date, and therefore it was then withdrawn. So I learned from Mr. Molefe that submission would have been stillborn because of the sentiments that were expressed by the PADC, that we'd already done it twice and that a 3rd one was not appropriate. So
you swallowed the last word, was not appropriate.
yes.
Yeah, okay.
Or they would not welcome it.
Okay.
Yes. So that's how we got to the new confinement to CSR, which, as indicated in what Mr. Maybeck said, I had a telephone discussion with Khaled, which I think he does not recall. He had phoned me, and I think maybe at the same time he also sent me the email. And so we'd had a discussion where he indicated to me that, look, there is a new submission, and that new submission is to CSR, and me and him then agreed that we did not currently have any experience of CSR doing a heavy haul locomotive, which was a 26-ton per axle locomotive. It was on that basis that I then sent an email to Singh that evening to say, look, this is what I hear that has happened. I think it would not be appropriate for us to try and confine this type of locomotive because we have no experience of it, at least in our country. The experience that we have is that one of Mitsui. I was still at that time unaware that the PADC had rejected completely any suggestion that Mitsui should have to have this confinement or this procurement confined to it. So I learned it after that submission from. So I think then it was at that time that Mr. Mlife and Mr. Singh had then submitted the CSR memo to the PADC, because if you look at the time period, it would have been submitted a day before the actual meeting, because Mr. Mlife had signed it a day before the meeting. So that is how it came about, that there was that new CSR memo.
Take you back to your affidavit. We had got to paragraph 49.1 where you said at the end it was at all times known to Callard that I supported the confinement. If I could take you over the page, page 153, that's 250.153. At 51.2, I recall having received a telephone call from Callard during the evening of 23 January when he informed me that the confinement to Mitsui had somehow been changed to a confinement to CSR. At 51.3, I indicated to him that I would liaise with Singh to establish what was going on. I sent the email referred to during the evening of the 23rd of January after my conversation with Callard. The email was premised on input provided by him. At that time, I'd not seen the email which Callard had sent to me. You say it's sub 4. I agree with Callard concerning the matters raised by him. Is that correct?
Yes.
And then over the page, 250.154, at 53.1, I did not support the confinement to CSR, in fact well known to Malefe and Singh. The memorandum to the BADC was not signed by me, that we've seen, correct?
Yes, that's correct.
Now I want to get to the minutes. And perhaps what I could ask you to do is to turn up and work with them together. BB4A would go to page 228. There you'll find the minutes of the BADC meeting on the 24th of January. And then I'll take you through your commentary on them in your affidavit.
What page on 4A?
Page 228, Chairperson.
Thank you.
What we see on that page is these are the minutes of the BADC meeting of 24 January. Present, Mr. Sharma, he was the chairperson. Correct?
Yes.
And then in attendance, Messrs. Malefe and Singh. And then we say you see partial attendance yourself. Is that correct?
Yes.
We then go to your affidavit at page 250.154. You say at paragraph 54.1, I've read the minutes, particularly at paragraph 5.22 of the meeting of 24 January of the BADC. You say at 54.2, it is clear to me that no one from TFR would have presented anything of the kind reflected in the minutes. As in by way of example, quote, management informed the committee that it was decided that a 26-ton heavy haul line by GE would perform better than a Class 19E locomotive by Mitsui. The aforesaid caption is nonsensical in that not only is the heavy haul line not a locomotive, but also that General Electric GE only manufactures diesel locomotives. And therefore the specifications cannot be compared with those of electric locomotives manufactured, for instance, by Mitsui. Then you quote again at 54.3, management motivated for the confinement in favor of GE. This was motivated by a submission that was previously withdrawn due to reputational issues that had emanated from an old newspaper article. Management requested for a contract extension for the Class 43E diesel locomotives by CSR. From the foregoing, it is clear that confusion reigned between the procurement of diesel locomotives by GE, in brackets 43D, and the procurement of electric locomotives either from CSR and or Mitsui. Consequently, no reliance ought to be placed on the aforesaid submissions, as they are clearly wrong and not representative of what had been discussed. However, what is significant was the fact that whilst I supported the confinement to Mitsui, the BADC had rejected my said proposal on the basis, as I understand it, that such confinement would have been the third with Mitsui. As it so happened, Brian Malefe later informed me that my Mitsui submission would have been stillborn. And then at sub 4, Singh and Malefe had removed my memorandum and prepared a new one, which they signed and presented to the committee, recommending CSR as the preferred supplier. You want to comment on that further?
Yeah, well, that's what it is. I think when they realized that the Mitsui submission would not be supported by the PADC, they then put in CSR. I think with us as people in the railway, we had not experienced anything of heavy haul from CSR, so we would not have made a recommendation that CSR should do it. It turned out much later that CSR did make such types of locomotives, but in China, and not we had not had sight of such a type of locomotive ourselves. So the confinement route would not have been one that we would have supported for CSR, because we did not know anything about their heavy haul capability.
Is your evidence to the effect that prior to this changed memorandum, or the one that was recommending CS confinement to CSR, prior to that memorandum being presented to the committee, you were not aware that there was a change and now the confinement was for CSR?
The only bit of awareness was the discussion that I'd had with Khalad,
yes,
which was the evening before.
Yeah.
I had then sent the email to say, look, I'm told that this is what is happening, but that you guys are not, going with Mitsui, you're going with someone else, and I think you might not be able to find what we are looking for.
That was an email to Mr. Singh?
That's correct, yes.
Yes. Which he never responded? Or did he respond?
The response, according to the records, he responded the following morning, which I didn't see, where he said we will discuss it in the morning.
But it was never followed up?
Yeah, no, it was never followed up.
Okay, would that be quite unusual that the committee would discuss a matter such as that relates to a particular division, and the head of that division is not aware of the latest position that's being presented to the committee?
Yes, no, it was unusual because I was unsighted on the...
Yeah.
Yeah.
Mr. Martha.
And that, as I understand it, your input was not sought on the revised business case.
No, it was not.
So, Mr. Gama, perhaps you can assist with this. Do I understand, I mean, was there a meeting of the BADC before the 24th of January where it decided against the confinement to Mitsui? Or was that informal discussions that were had with Mr. Singh and Mr. Malefe that then caused the change in the business case and the memorandum, and then the presentation of the revision on the 24th of January? Or do I have the sequence wrong?
No, there had been a meeting, but I had not received any feedback from that particular meeting. There had been a meeting, I think in November of 2013, where the PADC had rejected this, but I had not been privy to this. So I continued to send updated, what do you call it, Mitsui confinements to say, I now have an update. This is what it now looks like. Can you put it into the pack? But I had not received this feedback. I only received the feedback after the 24th of January that, look, this thing would have been stillborn. These guys had long rejected any procurement from Mitsui.
But your absence from that meeting of the 24th of November, you said you were absent in that
no,
meeting.
I had not been at that meeting. There was never a need for me to go to all the meetings.
Yeah.
If I was required at the meeting, I would then be...
You would be asked.
I would be asked.
Even if a matter relating to your division was going to be discussed, would you need to be invited? Or?
Yes, I would need to be invited. I mean, the GCE can make up his mind whether or not
he wants you to come along.
He wants me to support him there or not.
Oh.
If he felt that he could handle it, he would handle it.
Yeah, okay,
Yeah,
okay.
yeah.
Then if we carry on with your affidavit at 250.155, say at the time of sending the SMS, I'd already dealt with the matter as I'd spoken to Kellogg telephonically during the evening of 23 January 2014.
Yes.
And then you take issue with what Mr. Kellogg says at 54.1, and that is
On his 54.1.
yeah, where he said that it's incorrect. When you said, I just received your email, said that can't be correct because you had followed up on it. And you take issue with that.
That's correct, yes.
And then at paragraph 57 of your affidavit, you say, I note the professional opinion expressed. I don't differ from it and have no cause not to support it.
Yes.
And that's where he's talking about the concerns that he had.
Yes.
All right. And then could I take you to two other parts of your affidavit that are of some significance for present purposes? Could you please go to page 250.145. Sorry, my reference is wrong. I beg your pardon. 168. You're dealing then generally at paragraph 77 at the foot of the page with the acquisition of the 120 locomotives. You say TFR had set out to procure 100 locomotives from the coal line from Mitsui in line with the 19E acquisition. The BADC determined that we had utilized confinement as a procurement strategy with Mitsui on 2 previous occasions, and that this did not permit a third acquisition from Mitsui. The GCEO and GCFO subsequently requested a confinement to CSR, and the BADC agreed to the request. The decision was taken whilst I was protesting the appropriateness of the request, having regard to the fact that CSR had no established history with the provision of similar locomotives in South Africa. Subsequent to the approval of the aforesaid request by the BADC, which motivated its decision to the board, Transnet's technical design team engaged with CSR to create prototypes, whereafter the locomotives were delivered and employed on the coal line. They were named 21E series. You want to comment and expand on that?
Yes, I think after that meeting of the 24th, we were then informed that we should engage with CSR, which we did, and they then created the prototypes. Those 100 locomotives were manufactured, and in fact, with the benefit of hindsight, and sometimes ignorance can be interesting, because the people that signed the CSR memo were saying, look, they didn't know anything about locomotives, and these CSR locomotives, they are better than the Mitsui locomotive. And I think they've fed well. The Mitsui locomotives gave us a lot of post-commissioning teething problems. In the coal line, there were lots of issues around their adherence and all of those kinds of issues, which cost a lot of money in the sense that they had to be taken out for frequent repairs. And when the CSR locomotives came in, they did assist in terms of delivering record volumes on the coal line. And in fact, the customers were very happy, because for the first time after we took delivery of this, Transnet reached about 77 million tons of coal in 1 year, something that we'd never thought would ever happen. And that was as a result of these CSR locomotives that came through, these new ones, the 21E series.
I want to take you to parts of Mr. Singh's affidavit, if I may. And this you find, and someone will help you with this, Transnet Bundle 5C, Exhibit BB23.
Yeah.
Could I ask you to turn to page 1458?
So that's 1558.
1458, Chairperson.
1458.
Oh, it's in the second one. This one goes to, oh yeah,
1458.
the black numbers.
Yes, on the left-hand side.
This one goes to 142. One, 4, 5, 8.
Yeah.
Yes.
just wanted to ask you to have a look at paragraph 119. He's commenting on a paragraph in the Fundutsi report. Perhaps not, he says, I deny the contents of this paragraph insofar as it relates to the manner in which the confinement was prepared for these reasons. He says, Mr. Gama was the chief executive of TRF. Was for all intents and purposes the end user of the locomotives, as he was ultimately accountable for TFR as a division of TRANSNET. Sub 2, he was present at the meeting at which the confinement was present, presumably presented and approved by the BADC. Do you want to say anything about that?
Yeah, I was partially present. I cannot recall. You will see that that meeting dealt with a number of issues. It was not only the 100. It also dealt with the 1064. So I was partially present, but I don't have a recollection of my presence when the 100 was discussed. But I would also say that even if I was present, in those kinds of meetings, that's where you go to these meetings and you speak when you are spoken to. NgesiZulu ngeke kumane usukume nje bazokudonsa ngebheshu bakuhlalise phansi ucabanga ukuthi uzosukuma nje nihleli phansi kwesihlahla kunomhlangano wamadoda inkosi ingazange kukhona.
Well, you'll have to say that in English for the benefit of those who don't understand isiZulu.
I'm saying, Mr. Maybeck, that in these kinds of meetings where you are invited, you are a partial attendee, as it says. You speak when you are spoken to. You are there to provide advice if it is required. You are not there to express any new views or anything that you might want to do, because you're not a member.
You're not outside. A full participant.
You're not a participant of that particular meeting.
Mr. Gama, perhaps just before 9 o'clock, I found a reference that I missed just now. Could I ask you to go back to your affidavit or back to your exhibit 28 and to another of your affidavits, your second affidavit? Let me ask you to go to page 144. So this is in the beginning of exhibit BB 28. BB 28, so it's your exhibit, and to page 144.
250, 144.
144, no, not 250, 144. That's what I confused myself, I'm sorry. At the beginning, 144. Just at paragraph 30 at 144, you also deal with 100 locomotives, and what we find at 30.1 are things we've already dealt with. I just wanted to take you over the page, 145. At paragraph 30.2.1, the written recommendation to procure 100 locomotives from CSR was signed by the CFO, the GCEO at the time, etc., in circumstances where I was of the view that CSR did not have the capability to manufacture heavy haul locomotives. You confirm that?
Yeah, I confirm that.
And then the next subparagraph, 30.2.2, I was informed by the GCEO that Sharma, the chair of the Disposal and Acquisition Committee, ADC, had not permitted any further procurement by way of confinement from Mitsui. I deny that I was responsible for making a recommendation to the ADC and that I failed in my fiduciary duties during the acquisition of the 100 locomotives from CSL, I believe. You confirm that?
I confirm that, yeah.
Could you just give us the context of this discussion that you had with Mr. Molefe?
I think I've already said it, but I can repeat it. The context was that we had already confined twice to Mitsui, and that the PADC chair and the PADC had then said, look, there wasn't going to be a third opportunity for us to do that. So they had then, and I think that is at the time when they had actually withdrawn that submission that had been made in November. So that is the context.
And did Mr. Molefe make specific reference to Mr. Sharma, the chairperson?
Yeah, when we had the discussion, he said, look, the chairperson of the PADC, but normally it's not really, we don't work like that. It's really, it's the PADC in its totality. You can't hold one person. If the others agreed, it's the whole PADC. We don't have a system of singling out particular people per se, but yeah. That is what happened.
Yes, but you say on this occasion, even though that's not what is normally done, namely sending somebody out, on this occasion, the Mr. Molefe did. Or are you saying...
That is the information that I got, and that is the information
him.
that I claimed, yeah.
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 And what was your understanding of what he was saying, with special reference to whether he was saying that was the view that came from the chairperson, Mr. Sharma, of the committee, as opposed to saying that was the view of the committee? Do you have an understanding?
My understanding was that he had particularly been the one who was not very happy about it, but the whole committee concurred with it.
Okay.
Yeah. Chairperson, if this is a convenient time?
Yes, no, that's fine. We'll adjourn then. I think that therefore the arrangement about tomorrow is as we have discussed. And I suggest that maybe, Mr. Myberg, you could be in touch with Mr.
Yes, I'll do that
during
at
the lunch
lunch
break, and then you can share the information. Yeah.
Thank you, Chairperson.
Okay, all right. Thank you to everybody for your cooperation to enable us to sit up this time. Thank you, Mr. Myberg and your team and the investigation team. Thank you, Mr. Gama and your legal team. Thank you to the technicians and staff. Thank you very much to everybody. We adjourn.